The DEA almost never backs down. In 2016, they did. A plant called Kratom was 42 days from a federal ban. Then the public showed up, 142,000 signatures, 22,000 public comments, 9 United States senators, 51 members of Congress. The agency reversed itself. I'm Patrick Nolan. Today on Pat Talks Law, how a coordinated public comment campaign stopped a DEA emergency scheduling notice in 2016 and why that fight is happening again right now over 7OH. On August 31st, 2016, the DEA published a notice in the Federal Register. The agency announced its intent to place the two main active compounds in Kratom on Schedule 1 of the Controlled Substances Act, the same classification as heroin, high potential for abuse, no currently accepted medical use. The mechanism was emergency scheduling. Under the Controlled Substances Act, the agency can move a substance to Schedule 1 without a hearing, without a formal comment period, without the months of administrative proceedings every other rule change requires. The DEA just has to cite an imminent hazard to public health, and that is what it cited. The effective date was set for late September. Anyone selling, possessing, or shipping mitragynine or 7-hydroxymitragynine after the trigger date faced federal felony exposure. Vendors started planning to dump inventory or destroy it. Veterans tracking the docket started calling their congressional offices. The runway was 30 days. The notice was already in the Federal Register. That should have been the end of it. Kratom is a tropical plant, coffee family. It has been used for centuries in Southeast Asia by laborers and traditional healers. In the United States by 2016, the American Kratom Association estimated that 10 to 15 million Americans were using it, not a recreational user base. Veterans, parents, professionals, chronic pain patients, people in opioid recovery who described Kratom as the bridge that kept them off prescription opioids and off the street. The reaction to the August notice was not measured, it was raw. A retired Marine wrote that Kratom was the only thing that let him sleep through the night without VA opioids. A woman in Ohio wrote that her quality of life would, in her words, plummet to nothing. Another wrote that the only alternatives in her area were either prescription opioids she could not get refilled or the heroin she had spent 2 years climbing out of. The DEA framed the notice as law enforcement. The framing on the other side was clinical. Whether the plant works the way users describe is a question for the FDA. The question in front of operators, patients, and Congress in 2016 was different. Was the agency about to outrun the public on a substance with millions of users? Quick break. If this is the kind of legal news you want in your feed, hit subscribe and like the video so YouTube pushes it to other people watching how federal agencies actually work. Back to the story. What happened next was a masterclass in modern federal advocacy. The American Kratom Association coordinated. A White House petition cleared its threshold and kept climbing. By the time the petition closed, it had over 142,000 signatures. Then the comments. Under sustained pressure, the DEA opened a formal public comment period. That comment window pulled in over 22,000 comments. The vast majority were not policy memos. They were stories, patients, veterans, parents, each one writing in their own name, attaching their own circumstance, saying what a ban would actually do. Congress moved too. A bipartisan group of 51 members of the House of Representatives wrote to the DEA questioning the emergency process and asking the agency to delay. A separate letter from 9 United States senators followed. The letters were specific. They cited the scientific gaps the agency had skipped, the absence of public comment on the original notice, and the rushed posture of an emergency designation on a substance with millions of users. 3 pressure streams hit the same docket: petition, comments, congressional letters, all inside a 30-day runway, all built around individual stories, not lobbying talking points. 142,000 signatures, 22,000 comments, 60 members of Congress. The DEA backed down. On October 12th, 2016, the DEA officially withdrew the notice of intent. The withdrawal cited, quote, numerous comments from the public, end quote, and the need for a full scientific and medical evaluation by the FDA before any scheduling action. That is not an agency posture you see often. The DEA is in the business of scheduling, not unscheduling, and not withdrawing emergency scheduling notices after the runway is set. The withdrawal happened 42 days after the original Federal Register notice. 42 days. The activists did not get a guarantee. The DEA did not say Kratom was safe. It did not say it would never schedule Kratom. What the agency said was that on this notice, with this record, and after this volume of public comment, it was not going forward. The next decision would require what the agency had skipped the first time: science, comment, evidence, process. That is the legal record of 2016. The first and so far only time in modern DEA practice that an emergency scheduling notice was reversed by public pressure. That was 2016. The fight is not over. It moved. The federal stage went quiet. State legislatures filled the vacuum. As of mid 2026, more than a dozen states have passed versions of the Kratom Consumer Protection Act. That model law regulates the plant, product standards, age limits, lab testing. It is the alternative to a ban. Several other states have gone the other direction and prohibited kratom outright. The federal focus has narrowed. In July 2025, the FDA formally recommended that the DEA schedule 7 hydroxymitragynine, the more concentrated compound, not the leaf, the trace alkaloid that is now being sold in concentrated and synthetic forms in convenience stores nationwide. The DEA's review of that recommendation is open as of mid 2026. So the line is being drawn. Traditional kratom leaf on one side, synthetic and concentrated 7-OH on the other. 2016 settled the precedent. Public comment on the leaf works. 2025 and the years that follow are the test of whether the same coalition can hold that line when the next form of the substance shows up at the agency's door. Bottom line, if you use Kratom, sell Kratom, or watch federal agencies for any reason, 2016 is the playbook. Public comment is not theater. When the volume is high enough, specific enough, and signed enough, the agency reads it. The DEA backed down once. It can back down again. If a Kratom Consumer Protection Act bill is in front of your state house, call the committee chair's office. Get your name on the witness list. That number is on your state house website, not in this video. I'm Patrick Nolan. This is Pat Talks Law. If this kind of legal news belongs in your feed, like the video, subscribe, and share it with anyone who watches federal agencies for a living. More on the 7OH scheduling review as it